Hello, friends. I welcome you all to this 47th session of Law of Evidence. And today we are going to see one of the very important chapters of Indian Evidence Act. Many a time, certainly one question will be asked in prelims. A long question can be, or a short note can be asked in the mains examination, and in interview also it can be asked. So, this is very important topic and it is chapter 8 of law of evidence. It covers three sections: section 115, 116, 117. Today we will focus on 115 in certain points. So let us have a brief overview as to what all we are going to study today. So first we will see the nature, that is this principle of estoppel. Is it procedural or is it substantive? Remember that the Evidence Act is basically procedural in nature, but no act can be in black and white or in watertight compartment classified as procedural and substantive. So, this is one thing. Then we will see what is the basic principle, basic idea, the maxim behind this principle of or law of estoppel. Thereafter, its application. We'll see that whether it is applied in civil case or criminal case, anyone or all of them. Then we will try to define estoppel, though estoppel is not defined in the act anywhere, yet we will try to define it and make a simple definition. Then the types of estoppel which are there, and the sixth point will be about the essentials of estoppel, which are given in the section 115 of Indian Evidence Act. Then, what are the various exceptions to which it applies? So, these 7 points we will see today. Point number 8, 9, and 10, which are promissory estoppel, estoppel against universities, and estoppel compared with some other concepts like admissions, waivers, res judicata. These three aspects, along with section 116 and 117, we will be looking after in next class. So let's start with the basic maxim on which this law of estoppel is based. So the maxim says elegans contraria non est audendus. That is, person alleging contrary fact will not be heard. The person who alleges contrary fact, that is, he's at one time he says that this particular thing belongs to him, and at the other time he denies that this particular thing does not belong to him. So because of his this statement, if someone has believed him and has paid him or bought him by paying him something, then he cannot be allowed to deny it, because then if he is allowed to deny it, then that would lead to fraud. So in order to prevent, the basic principle behind it is to prevent fraud and to secure justice, so that good faith between the parties contracting can be there. This principle is also referred to as a man cannot approbate and reprobate at the same time. That is, he cannot uh, ascertain a fact, at the same time he cannot, suppose a person asserts this fact and after some time he denies this fact. So this cannot be allowed, because then that would lead to fraud as such. And or other, it is also said that a man cannot blow hot and cold at the same time. So we cannot say that it is hot and cold at either it is hot or it is cold. We cannot say it is raining or not raining at outside, whether it is raining or whether it is not raining. So the principle is, or the basic motive is to prevent fraud behavior. And this question has also been asked many a times, that is based on which, or it is founded on which case law. So that case law is Picard versus Sears. It is 1837 case law, and on this the principle of estoppel is based. Remember this case law, remember this maxim, it has been asked many a times. So we have now done the principal aspect of it, or the maximum behind it. Maxim behind it is to prevent fraud. Now the nature of it. See, as far as its nature is concerned, nature of law of estoppel is concerned, then it is substantive in nature. And that is what which makes this concept also important, because the evidence act is a procedural act, and procedural act is normally um, the evidence act is procedural in nature, and in procedural act normally procedures are mentioned, but this is one exception where substantive nature of rights have been provided by the principle of estoppel. This question is asked in interview many a times, please remember it. Now we have done its nature, principle, then application, that whether it applies in civil or in criminal case. Remember that on it the principle of estoppel applies only and only in civil cases. In criminal case there is a concept called issue estoppel, that is, if a particular fact has been established in a particular court of law, then evidence cannot be given to deny this fact. So this is issue estoppel that we will learn when we will be doing CRPC. But remember, as far as law of estoppel is concerned, it applies only and only with respect to civil cases or civil proceedings. Now, definition of estoppel, or what does estoppel means? So the if we say definition, then we can say that if a person alleges or asserts some fact, later on he cannot be allowed to deny it, as he becomes bound by it. So if I make certain statement, then I am bound by that statement, and as I am bound to by that statement, later on I cannot be allowed to deny that particular fact, because it is what I myself have asserted, and I myself cannot allow to deny it as I become bound by it. So this is what is the definition, or simple definition of estoppel can be. Now let us see the three sections which are involved in it, or that is, so that you can remember the three sections. I have kept the word dim, so it's dim light, DIM. So D, that is the definition aspect, is covered under section 115, where the essentials of Estoppel are provided. So, and regarding immovable property, it is mentioned under section 116, and regarding movable property, it is mentioned under section 117. So today we will be just doing section 115 as such. So now let us see what are the basic essentials of the law of the estoppel. So what is the section says, section 115, chapter 8. When one person has by his declaration. So one thing is that there should be a declaration, act or omission, intentionally caused or permitted another person to believe a thing. So the other person, this person says something or makes a representation, and this person meekly he believes in it. He believes what is said by him, believes the thing to be true, and to act upon such belief. And after that belief, he acts upon it. He makes something. Neither he, that is, neither this person who has made the declaration, nor his representative, nor anyone who is his representative, shall be allowed. The word used is shall, remember, be allowed in any court or proceedings between himself and such person or his representative to deny the truth of such thing. So, if he has made a representation and this person A has made a representation, person B has believed it and has acted on it, then A or his representative cannot be allowed to deny this fact, what representation he has made, in a suit or proceeding between A and B or representatives of A and B. So, this is what is section 115. So A intentionally and falsely leads B to believe that certain land belongs to A. So suppose this is A and A says to B that see, this land is actually mine, but A knows that it is false and thereby induces B to buy and pay for it. And what B they says is that B gives some money to A and buys this land. The land afterwards become the property of A. Now suppose the land was actually of C and C has later on transferred this land to A by will. So later on the land now belongs to A and A seeks to set aside the sale on the ground that at the time of sale he had no title. Now A have got the land. So A thinks, fraud enters his mind and he thinks that why not set aside the sale, because, and he takes the plea that at the time when this sale was done, this land actually didn't belong to him. So then it says that he must not be allowed to provide for want of title. So he cannot be allowed, he will not be allowed to say that at that time he didn't have title because he made a representation. Now, what are the essentials? To, in order to remember essentials, I have made a small um, acronym as usual. So that acronym is BAR. So as you can see, it is a bar, bar where we go and take some drink. Now, B is belief. Say, suppose the transaction is between A and B. The B, the party who claims the benefit of estoppel, he should believe in the representation that was made by A. That is, it is not that B would actually be knowing, if in case the B was actually knowing the fact, the truth that this particular land does not belongs to A, then B will not get any benefit. So B should rely on the statement of A. However, it should also be that by ordinary prudence, B would not be able to discover whose land actually it is. So there should be a belief by the other party or the party who have suffered. That is, there should be a reliance on the representation. Then A. Now, in case there should be an act detrimental to the interest of the party aggrieved. Now, B, believing the representation made by A, should have changed his position or altered his position to such a way that he has suffered some loss. So, suffering of loss is important in these cases. Now, the most important thing is there must be a representation. So, the party against whom the estoppel is claimed, suppose against A estoppel is claimed, then A must have made a representation on which B has believed and acted to his detriment. Now, this representation should have certain feature or is classified. One is that it may be intentional or it may be unintentional. In both cases, this would apply. That is, the uh, law of estoppel will apply. So, in Sarat Chandra Day versus Gopal Chandra Laha, it was held that even if the person has unintentionally, the person has no intention